Yes, really appreciate you taking the time.
Thanks for having me, David.
So bankruptcy is something that you are an expert at and that I am fascinated with and also in a lot of ways grossed out by. And you have a recent paper that kind of, I think, summarizes why I am kind of grossed out by how the bankruptcy system is being used. Your paper talks about how the bankruptcy code in a lot of ways is punishing regular human beings and protecting what you call fake people, which I think is kind of a stand-in, that term, for corporations. Give us a broad overview of what you mean by that. Why are real people and fake people treated differently in our bankruptcy system?
Well, I'm glad you're getting fascinated with this topic because it affects so much more than just a narrow subject of a couple debts being restructured from time to time. And our legal system has so many kinds of bias in it. This is really just one. When I'm talking about fake people, I do mean big corporations, but I also mean nonprofits. I mean sometimes cities and other kinds of municipalities. Anything that gets created by the fiat of law rather than being a human. And here's the situation that we have. Financially distressed families, when they encounter bankruptcy, they face many restrictions on the debts that they can cancel or restructure. Their cases are nitpicked for mundane spending choices. The design of the system really is about deterring people who need it most. And it's hard to understand why that would be a good thing given the role bankruptcy fills. Now, there is nothing cheap or easy about Chapter 11 for big corporations, and yet they have really well-advised folks that help fake people, big fake people, cancel and restructure nearly all debts. That could be not only loans to banks, but harm from hazardous products, sex abuse of children, employment discrimination, and even police brutality in city cases. So there are a lot of other distinctions that we won't go into right now. But a lot of it is justified to the extent it's talked about at all as, well, in these business cases, these big cases, we need to maximize economic value, just get a deal done. And so moral hazard, never mind.
I want to ask about this example that you use in your paper, because I think it's really illustrative of what we're talking about here. That there's this example of a guy named Ronald Temecki who lost his home. And in the same court, there's the example of Johnson and Johnson. Give us a rough sketch of the differences between how this court, as an example, treated somebody like Ronald Temecki and how they are treating a giant corporation like Johnson and Johnson, which has been accused of essentially poisoning tens of thousands of women with baby powder, talcum powder that included carcinogenic ingredients.
Yeah, so the first thing we should remember about Johnson and Johnson is that the story is still to be written. So that court just heard the case a couple of weeks ago, but one thing we can be sure of is that they are talking about it in a very different way. And I don't think it's going to look much like the individual that you mentioned, Ronald Temecki. So Ronald Temecki only had one asset in his bankruptcy. It was a home he built with his own two hands. And his case got challenged and ultimately thrown out of bankruptcy because a trustee, a watchdog over the system, which most big business cases do not have, thought that he was delaying a divorce so that he didn't have to share some of the value of his home with his creditors. His creditors didn't even complain in the case, just the trustee. But out he went. It was considered not to be a good faith filing.
So he doesn't get bankruptcy protection on a $35,000 credit card debt on a home that he built with his own hands, because the bankruptcy trustee, the overseer, says, I think you're not getting divorced in order to try to protect your assets. Okay, so that's how the court treats this guy, Ronald Temecki. Now, the same court, how is it potentially going to treat Johnson and Johnson, a multi-billion-dollar corporate behemoth being accused of poisoning tens of thousands of women?
Well, Johnson & Johnson is a really wild example, but it's not alone, and it will definitely not be alone depending on what happens here. Yes, it had 38,000 claims of allegations that its products created ovarian cancer or added to ovarian cancer, caused ovarian cancer, and there was an absolute failure to warn. There are also mesothelioma claims. And Johnson & Johnson didn't like the way the jury system was going in state courts and other courts around the country. It said those were lottery-like results, that real people were ruling on these cases. And so it came up with an idea to put all of its talc liabilities in a separate corporation, a separate entity, and toss that entity into bankruptcy. But there's a catch. Johnson & Johnson wants to protect the entire corporate family. It wants to continue to pay dividends to its own shareholders and use all the profits for other things and devote some money maybe to these claims, which Johnson & Johnson says there is no validity to, but put a little bit of money in there, but otherwise say we can just hedge off or hive off these liabilities. They put the liabilities in bankruptcy, but they're paying everybody else. They're paying their commercial creditors. Their shareholders are fine. And so that case has been challenged, and then we'll see.
So what's amazing here is that I think a lot of folks will hear this and be like, wait a minute, I didn't know Johnson & Johnson was bankrupt. What are you talking about? Johnson & Johnson's a highly profitable company, but they are going into bankruptcy court, or at least they've severed off a piece of their company and had that piece of their company try to get bankruptcy protections because the company doesn't want to trust the judicial system, juries, the most basic part of our court system, to judge whether it did in fact poison tens of thousands of women and whether it should be liable for that. Because I want to talk about this maneuver. How does a company sever itself? There's this thing that's now called the Texas two-step. Tell us about what the Texas two-step is, how it relates to the bankruptcy system.
Well, every day, new business entities can be born. They also can be terminated. So it takes very little to create new enterprises. And in some states like Delaware, you have several hundred of new limited liability corporations every day. To do what Johnson & Johnson did required a couple of extra steps. So they had to go back and forth between a couple of states, including Texas, that has some special rules about dividing up companies. And so they have very sophisticated legal advice, lawyers who have shopped this idea around to others, and then come up with a company that only has basically the liabilities, some royalty rights, and then a funding agreement where they're supposed to get some money from the bigger company to actually compensate some of these survivors according to whatever is negotiated behind the scenes. Now, that backdrop of coming up with that company is supposed to make it more likely that it can survive a bankruptcy. And that, again, this remains to be seen. I do think it's important that people know that that those who are more accepting of this strategy, here's some of the argument that they sometimes give. That they're trying to do the least worst thing, that all the money will otherwise go to paying lawyers and appeals, and it's going to take years, and they just want to bring finality to the whole thing. So maybe bankruptcy is a good place for that. Now, I don't personally agree with that, but it goes back to this economic efficiency argument. And I think that can be very persuasive in courts to say, well, maybe the survivors are better off. Maybe the victims are better off if we can just cut a deal through a mediation in this bankruptcy. So that's sort of some of the dynamic there.
But to go back to the point about regular, normal people and the way they're treated in bankruptcy court versus a fake person, a giant corporation, a regular person cannot cut off their arm and have their arm only go into bankruptcy court. It seems to me that the Texas two-step, where there's this state law that was changed in 1989 to allow companies to divide into two or more entities, to basically isolate the profit part of the company from the liable part of the company. That's a good example of a kind of privilege that a fake person has in these courts that a regular person doesn't. Worth adding, this was pioneered. This technique was pioneered by Koch Industries when it used it to shield a subsidiary, Georgia Pacific, from asbestos claims related to its paper and its building products. So just to underscore that this maneuver, and Johnson & Johnson being the fourth major company to try it now, this maneuver is another example of a thing that a regular person in bankruptcy court can't utilize. Now, I want to turn to the Sacklers for a second here, because it seems to me they're using a different technique. And we're going to run through some of these techniques because they're kind of mind-blowing. Seems to me that the Sacklers are of the opioid empire, Purdue Pharma. The Purdue Pharma has declared bankruptcy. The Sackler family, worth noting, has not declared bankruptcy. But there's this issue in that case, a different issue with what's being called a third-party release. This kind of blows my mind as well. Can you tell us about what these third-party releases are and how they can potentially shield a billionaire family from the bankruptcy of its own company, a company accused of poisoning effectively hundreds of thousands of people?
So in bankruptcy in general, one expects to match obligations with rights and benefits. So typically the party to get protected, to get debt cancellation, to get relief is supposed to be the party that's in bankruptcy itself. And certainly for individuals, that's of modest means, that's the way it works. So both in Johnson & Johnson wants the same thing that the Sacklers do. They want the benefits of bankruptcy without all of the obligations. They want to cut a deal that says, okay, we'll put in some money, we'll disclose some information, but we're not subjecting ourselves to be debtors and everything that goes along with. Now, this is a doctrine that the third party release concept is something that says you can piggyback off of someone else's bankruptcy in rare circumstances. Now, every time you say rare circumstances, you say, it's not going to end up being that rare. And that's part of what we're seeing here. We're seeing a creeping growth of the circumstances. Because once upon a time, you'd put the major tortfeasor in the bankruptcy and say, well, there are a couple people that are sort of associated with this. Maybe they should get relief too. But some of these cases are turning that concept around, where the ones that are putting in the most money or who might be most responsible for the harm are staying out of bankruptcy. And this is something we're going to hear any day now, what an appellate court thinks of Purdue Pharma's plan. Now, again, I have to say here, behind the scenes, there was pressure to come up with a deal, to have many people who were invited into the negotiating table to say, okay, we will accept this if a certain amount of money is put in. As always, the question is who gets invited to the table,
Right.
who speaks for whom. So that's some of the dynamic.
But just to be clear about what's going on here, the third-party releases, tell me if I'm wrong here, that the third-party releases basically say that if this bankruptcy deal goes through, that attorneys general, government law enforcement agencies cannot subsequently prosecute or go after the Sackler family, or cannot, in the Johnson & Johnson case, cannot go after Johnson & Johnson, because if the bankruptcy deal is essentially blessed by the court, these releases provide a permanent legal shield for any of the potential accusations, potential crimes that were committed in the past. Is that right?
Well, here we do have to distinguish between civil and criminal and the scope of the protection. So bankruptcy really, I'm sure people would like to try, but if these releases are upheld, it will not prevent criminal liability. The problem is how difficult it is to pursue that line. And I think there's an expectation that that's not going to happen. That doesn't mean it can't, but the bankruptcy would not stop that. However, it is a very significant shield against liability for opioid-related accusations. And here, the states were very well represented here. They advocated very strongly for themselves. Not all of them originally came on board, but eventually many came around, most came around. One thing that bugs me about the deal here, in terms of speaking of real people again, this opioid family survivors who had so little money to even for burials, for medical care, for rehab, they're not getting very much money out of this settlement. And yet there's still a fear that if the deal falls through, they would get even less. And that's always the threat. That's what's going on in making these cases go forward. The idea of, well, if you don't approve this, if we don't do this deal, the Sacklers are going to hide this money from you forever. So it's beyond the bankruptcy system what we have going on here, but the bankruptcy system shows this bias and how much protection for the wealthy that our legal systems offer.
Let's talk now to another abuse of the bankruptcy system, or alleged abuse: forum shopping. The idea that the corporation declaring bankruptcy can effectively shop for the most friendly court. In the Purdue Pharma case, you have a situation where Purdue chose to file its bankruptcy petition in White Plains, New York, where it knew it would receive one of the friendliest receptions available to its argument that Purdue Pharma's bankruptcy should forever shield the Sackler family. You've got a situation in the Johnson & Johnson case where it goes to Texas, it splits itself into two, then it goes to North Carolina, then it's in a New Jersey court, now it's in a Philadelphia court. Why are these entities allowed to just run around the country choosing where they get to have their bankruptcy proceedings heard rather than having to file it in the place that they do business?
It's a great question. And one that has defied an easy answer. It is an example of when you can continue to create new entities and new fake people, you can manufacture a situation where you could file for bankruptcy almost anywhere. With the Boy Scouts of America, a tiny subsidiary in Delaware was the hook to file that entire case there. The fault starts with Congress. Congress wrote a very flexible statute many decades ago. I think they expected more cases to be moved around once they were filed. And there are very good reasons that does not happen. And that's not a reasonable solution. I will say that what people are looking for and what these companies are looking for, of course, they want the best result for their client when the lawyers are plotting out what the options are. But there's also an advantage. It's not always that they know how a court will come out, but they're limiting the range of options. So even courts that have a very strong reputation, the Manhattan court has a lot of judges now. They're not all of one mind on many things. They could not predict which judge they would get in Manhattan, but they could in White Plains. Now, New York has shifted their local rules so that this situation can't happen again. But I think it's going to take a bigger congressional change because lawyers are going to do the kind of planning that they think they're entitled to do. Then they're getting paid very large sums to do that planning. But don't try that if you're an individual. It doesn't work.
Well, another example of what fake people are allowed to do in bankruptcy court that real people aren't. Okay, one last question about the abuses before we get to potential solutions. In the Alex Jones case, Alex Jones faces a potential up to $1 billion in damages in a judgment about the defamation case about the Sandy Hook shooting. His company is filing for bankruptcy. Bloomberg reports a looming question over that company's bankruptcy is whether damages in a case like that can be discharged. I guess, in other words, whether somebody can be found guilty of defamation in this case in an absolutely horrific way, and then use bankruptcy court to protect them from having to pay out those damages. Are those kinds of damages dischargeable in bankruptcy? Can you get out of having to pay damages from a court ruling like this through just saying, hey, listen, my company is bankrupt? And to be clear, Alex Jones is saying he himself personally is not declaring bankruptcy.
I first need to distinguish the Alex Jones terrible situation from some of these other cases in this respect. And to use the children's educational shows, one of these things is not like the other.
Right.
So Alex Jones doesn't have access to the elite lawyers that some of the other companies we've talked about has. That's changed the way these cases have already gone, and it has made it very difficult for those cases to proceed in the way he and his companies have wanted. So I do want to be cautious of how we talk about this. It's very early in those cases, but I'm not persuaded he's going to be able to do the kinds of things that the Sacklers may be able to do. And I think that's important context. There's been a lot of, the case has to have due process, but there have been a lot of rulings already that have suggested that this is not an easy hill for him to climb, for sure. Now, as to what debts can be canceled. Now, in general, fake people can, if they can get through a plan, or get through a case, they could cancel pretty much anything, even for a horrendous tort that they've committed, willful and malicious injury and that sort of thing. There are a couple wrinkles for Alex Jones and his company that are going to come up here. And I think there are going to be other wrinkles they're going to have. But here's the issue. First of all, I believe that the original judgment in the Connecticut case was a default judgment, that it wasn't actually litigated. He didn't come in and fight the allegations. That means that sometimes when you go into a bankruptcy court, the question is, what kind of deference do you give that judgment because it wasn't actually litigated? Do you need to relitigate it or have more of a trial? Which, given how much the people have been through already, the Sandy Hook family, sounds pretty horrendous. But that's one question. And that's assuming, well, another wrinkle here. Somewhat oddly, Alex Jones claims that his businesses fit a special set of provisions for small businesses that are supposed to make it easier to reorganize. Now, this is a very recent thing because typically small businesses have been treated more like humans and way less like, say, a Johnson & Johnson or Purdue Pharma. A lot of scrutiny, hard to actually restructure. That recently changed in 2020. It certainly was not designed for the Alex Jones situation. It was designed for the ice cream shop down the street. But so there's some question about whether this even fits that parameter. If it does, there is some case law percolating that says, well, maybe a small business is treated more like a human and therefore cannot cancel some of these debts. So sorry to get in the weeds there, but the question sort of demanded it to say there really are open questions here about how that liability would be treated. Again, assuming the case even gets that far, there are some real big challenges.
Let's talk about solutions here. There's a bill before Congress that the Lever has reported on called the Sackler Act. That's the first proposed solution to some of this. It would prohibit a bankruptcy court from releasing non-debtors from liability for suits brought by government entities. So basically, as I understand it, if an attorney general or the Department of Justice brings a suit against an entity or a set of entities, it's basically saying a court like the White Plains Court in the Sackler case can't just say, sorry, the Sacklers as a family get to be protected from those civil suits because their company, Purdue Pharma, is in bankruptcy court. Is that, in your mind, a decent solution? And I should mention, by the way, Johnson & Johnson has also been lobbying on this bill, not coincidentally. Is that a solution to essentially say to courts, you can't give these legal shields to the people behind the entities that are filing for bankruptcy? And I should ask, is there a danger in doing that? Like, what's the devil's advocate argument to not do that?
A couple things there. So on the specifics of that bill, David, you rightly pointed out, privileging the government as creditor over other kinds of claimants, that itself is quite controversial. Now, I have some sympathy for it on the one hand, to the extent they're exercising police and regulatory powers. These were not things that were supposed to get wrapped up in bankruptcy. It sometimes is hard to tell the difference between trying to collect money and police and regulatory power. But there's a real concern. I go back to the Sackler and Purdue. The way that the negotiation on behalf of the families, the survivors of the opioid crisis, who have lost so much financially themselves, were not given as good of a deal as the states. So you are pitting one group of parties against another, one group of creditors against another with that particular approach. I do think that because lawyers for big corporations and very wealthy families are going to continue to push the envelope, something's going to happen. Congress is going to step in. One day the Supreme Court might say that many of these things are not even constitutional. What is all this doing in a bankruptcy court? It just doesn't make any sense. So I do think some day of reckoning is coming. And I can guarantee you that the very well connected parts of the restructuring bar, that's the fancy name for very highly paid bankruptcy lawyers, they will be out in force with these companies lobbying against that and saying the sky will fall. So here's the devil's advocate. Sometimes this is the only way to get the deal done. We have to resolve all of these integrated liabilities. We can't silo them company by company. That's one of the main arguments that often made. So by banning third-party releases, so the argument goes, this will undercut the ability to compensate the very people that you want to help.
Right. So you're saying the releases are used as a way to entice the debtors or the accused to come to the negotiating table. Hey, I will agree to give up. We, the Sacklers, will agree to give up X billions dollars as long as we now have a shield. And I guess the argument is to prevent that from happening, you deter the Sacklers from agreeing to any deal. Now, I'm sure people listening to this are like, screw the Sacklers. Why do they get to dictate the terms of whether they come to the table? They're accused of doing horrible things. Why are they the ones who get to dictate the terms? And I sympathize with that impulse. I sympathize with that idea that it's unacceptable that those billionaires or that Johnson & Johnson or any other huge corporate behemoth gets to dictate the terms. Let's turn to the question of how to fix the Texas two-step. This idea that a company can sever part of itself and let only the part of itself that it wants to get rid of get bankruptcy protections and sever the rest of the company from any kind of damages. Is there a way to stop that? Is there legislation? What's the way to stop that? Because to me, that's like the end of the world, right? If a company knows that it can abuse thousands, if not millions of people, and just then when somebody calls them to account, just sever that part of itself from the rest of its profitable operations, then there's no deterrent. That's like the end of civilization. Is there any way to stop it?
So it's important to note that none of the Texas two-step cases that I'm aware of have made it all the way successfully through a bankruptcy. So it remains to be seen whether this works at all. I believe Senator Warren has a bill that goes to the Texas two-step, but I also think we're framing this issue way too narrowly. Now, end of civilization, maybe that's not too narrow, but I think that's really more of the point. Bankruptcy is swallowing the whole world. And so we could have one bill that goes after the two-step and another bill that goes after non-debtor releases. But the problem is bigger than that. The problem is the bias in the law. The problem is the protection of wrongdoers. And the problem is that our legal system makes everything about money and relies heavily on litigation and damage awards for money to compensate for a harm, which then feeds right back into this. That's not always the form of remedy that parties may want. That's not the form of remedy that may do the most to prevent these things in the future. But I think we're going in a vicious cycle here, and you can nip one of these things in the bud and the market will come up with a new one. Now, that's not a reason not to try. I'm not one of those don't do anything because they'll always come up with something else. But I think we need to think bigger about what the problem is, and that these narrow interventions aren't going to be as effective.
I think that's a profound point about money and criminality. And I think that's a good place to end this discussion, which the idea that the government in lots of cases has decided to use financial punishment against fake people, corporations that are not people, that are immortal, that can live forever, that have all these special rights. To my mind, what happened from the financial crisis onward was this idea that we're not going to actually prosecute individuals. We're not going to shut down companies, give companies the death penalty. The last major company I can remember being given the quote unquote death penalty, if I remember right, the big one was Arthur Andersen. That we were a country that used to prosecute individual wrongdoing. And part of the reason why we did that was the deterrent effect, that if a corporate executive knows that if they abuse tens of thousands of people, millions of people, and that they themselves could face personal liability, criminal liability, or at minimum, the company knew that it could face a so-called death penalty, pulling its charter, killing the company, et cetera, et cetera. That was a much bigger deterrent to abusing thousands or millions of people then, hey, we may have to pay a fine in the future that is either a rounding error in our corporate earnings, or one that we can now go into a bankruptcy court using something like the Texas two-step to protect ourselves. So I guess the final question is that ultimately where we are right now? Is that why we have these problems? Because at the 50,000 foot view, that our government entities are not adequately using the criminal enforcement mechanisms, or not adequately using tougher sanctions against companies beyond financial penalties, that we are there because the government isn't doing that, which then allows the bankruptcy system to be used as a shield wrongly in this way. Is that why we're here?
I'm not sure that's why we're here. It may be a piece of it. My colleagues who specialize in white collar crime and related criminal issues, I think, are divided on the role of the criminal law system in deterring wrongdoing by corporate actors. And they'll probably debate that until the end of time, as academics do. I would broaden the lens again. I think, of course, the government as enforcer of criminal law plays a role, but so much of our legal system actually depends on civil liability and upfront shaping how people treat each other, how careful they are to create the product in the first place, how oversight works all along. And so I do think all of these pieces could have deterrent effects. And again, bankruptcy is not directly responsive to criminal liability. We're really talking about the civil there. But again, it is all of a piece. And there is something going wrong in this legal system that makes big fake people. And again, I don't want to limit it to only for-profit corporations, because it can be true for municipalities and big nonprofits as well. Just less accountable than they need to be. And it's hurting a lot of people in different ways. And so bankruptcy is one small piece of this, but I wrote the essay because it's still an important piece. And the more that companies come to bankruptcy as a way to weave their way through this, it is not doing its part as part of the project to deter, punish, and rework how companies behave in our society.
Melissa Jacoby is a professor of law at the University of North Carolina, an expert in bankruptcy law. Her article on the ways that the bankruptcy courts treat regular people and fake people differently. We will link to it in the description of this episode. Melissa, thank you so much for your time today.
Thank you, David.